Nnamdi Kanu's case and what is expected today in court. The ongoing terrorism trial of Nnamdi Kanu, leader of the Indigenous People of Biafra, IPOB, at the Federal High Court in Abuja, has reached a critical juncture as proceedings resume today, November 7, 2025, before Justice James Omotosho. After the prosecution closed its case in June 2025 with 5 witnesses, the court rejected Kanu's no-case submission in September, ordering him to enter his defense. However, Kanu, now self-representing after dismissing his legal team, has repeatedly refused, arguing that the 7-count charge is invalid as it relies on the repealed Terrorism Prevention Amendment Act 2013, superseded by the 2022 Act. According to Omotosho, today's hearing is positioned as Kanu's final opportunity to present witnesses or evidence. Failure to do so will lead to his case being deemed closed, potentially paving the way for judgment. Expectations center on whether Kanu will finally open his defense or persist in challenging the court's jurisdiction, a stance he maintained during the November 5th session by citing constitutional provisions like Section 3612, which prohibits conviction under undefined offenses, and Supreme Court precedents such as Madukolam v. Nkemdilim, 1962. Legal observers anticipate a tense exchange, with Justice Omotosho likely urging compliance, while the prosecution, led by Adegboyega Awomolo, SAN, pushes for closure after Kanu exhausted 5 of 6 allotted days without action. Kanu's supporters, including Aloy Ejimakor, view this as a politically charged trial, emphasizing his right to self-representation and the need for the government to amend charges per a prior Supreme Court directive. Complicating matters are fresh allegations of obstruction by the Department of State Services, DSS, where Kanu is detained. His family and lawyers, including Barrister Maxwell, reported on November 6 that DSS operatives denied him access to consultants, family, witnesses, and essential documents for filing, potentially hindering his preparation and even his court appearance. This echoes prior complaints of eavesdropping and withheld files, raising fears of a forced absence that could be deemed waiver of rights. International attention is heightened, with Kanu reportedly writing to U.S. President Donald Trump on November 6, attaching annexures on the case's implications for Biafran self-determination, urging monitoring to prevent perceived persecution. Broader implications loom large. A conviction could ignite unrest in Nigeria's southeast, fueling Biafra sentiments amid global scrutiny of judicial fairness. Conversely, upholding Kanu's jurisdictional challenge might lead to charges being struck out and his release, vindicating claims of trial under a non-extant law. As the world watches, today's outcome may not only determine Kanu's fate, but also test Nigeria's commitment to constitutional supremacy and fair hearing, with calls from IPOB for immediate release echoing Section 1(3) of the 1999 Constitution, which voids inconsistent laws. Stay tuned for more update. Family Writers Press International,